But for somebody who has substantial risk, substantial assets, many of them are very interested in pursuing this as a remedy. So that's all I'll say for the time being. We'll come back to this topic, and I'll easily give one, maybe several shows to discussing this. Then there's the onshore trust. Now, the onshore means a domestic trust, and again, a domestic irrevocable trust. Now, some people would argue, myself included, that you can have a measure of safety here in the United States in a number of jurisdictions. What's nice about trends in the United States is that a number of states, similar to what I described, this trend to pursue business and investments and other things in these countries by offering secure legal environments or relatively safe legal environments, a number of states have been doing that as well. And in order to explain this, I have to come back and set it up a little bit. Traditionally, in most states, what the law has been is that when someone creates a trust, that's the settlor, or the person who creates the trust. When a person creates a trust, it's called a self-settled trust. Now, a person can create a trust in which they create what's called a spendthrift trust, which is irrevocable, and it has rules in the trust that avoid creditors being able to collect from the beneficiaries. Now, the common scenario is where a parent may create this trust for a child, and the child may go out and be somehow wasteful in terms of managing the assets. The child may be prone to squandering what's been given to him. So this is created to provide some protection to the child. So a spendthrift trust that is created in this way will often hold up. In almost every jurisdiction, I think, in the United States, you can have a spendthrift trust. Now, here's the distinction. A self-settled spendthrift trust is one in which the settlor has provisions that protects his own assets when he's the beneficiary from his creditors. So do you see the difference? Most jurisdictions, most states are comfortable with the idea of creating a jurisdiction or creating a trust in which you transfer the assets and you have rules that protect your beneficiaries, your children, others, from their own profligacy or wastefulness or whatever problems they might have. Many of these children may have drug or alcohol problems. So these serve legitimate purposes, and they essentially prevent the creditor from accessing what's called the corpus of the trust, the assets in the trust. They're protected. The only way the creditor can get to what's in the trust is when the creditor pays it out to the beneficiary. Once it's in the hands of the beneficiary, then sure, the creditor can come and collect the money through the collection means that with which you are probably already familiar and hopefully have not experienced personally. So that's a huge help, because it allows the trustee who's managing this trust to decide not to dispense the money when there's judgments out there waiting. Now, often a way around that to still be of assistance to the beneficiary is that trustee can pay the beneficiary's legitimate creditors directly. So if there's a landlord, a check can be issued to the landlord directly. That's not placed in the hands of the beneficiary, and as a result, it's not subject to these existing claims or judgments out there against this beneficiary. But now let's go to what most states historically have forbidden, and that's where the settlor, let's say you create such a trust, you transfer the assets to this spendthrift trust. It's an irrevocable trust. You transfer your assets there, and you have a rule that's created in your trust that your trust cannot pay out money to your creditors that might come after you. Well, you can see how this has a certain taint to it. It smells bad. And as a result, most states have said, no, we won't allow you to protect yourself with a spendthrift trust. If you create a trust and has spendthrift provisions, your creditors can still come after those assets. So just in the last, I guess I would say 10 to 15 years, a number of states have said, if we were to amend our uniform trust code or our trust regulations in our state to where we can allow people to create a certain asset protection provisions in their trusts, then that might prove very attractive to people to bring money and assets into our state. This could be hugely helpful to our economy. So why don't we change our statutes to accommodate that? This reminds me a little bit of permitting gambling. That was the original idea, in which you had Nevada and then you had New Jersey and before you know it, you had a couple more states, and then finally, though, once everyone's doing it, then it's lost its allure and charm, and it's not as beneficial to those few that do it. And it may be a similar trend, incidentally, with respect to asset protection planning. It started out, I don't know the order of the states that have done it. I know presently Alaska has a very favorable trust laws to allow you to create such a trust. Delaware has very favorable laws. Missouri is reasonably favorable. And there are about 7 or 8 other jurisdictions that have passed legislation that's intended to permit you to create a trust and yet be protected from your creditors through that irrevocable trust. That's a domestic asset protection trust. And again, there's much more to be said about this, and we'll talk about it on future shows. But here's one concern that some writers and some lawyers have had regarding using this as a tool or a tactic in asset protection planning. In the United States, among the states, you have what's called full faith and credit. Full faith and credit means that states agree that they'll acknowledge judgments created in other states. So some have argued that you can't have a lot of peace of mind by creating these entities, because if California issues a judgment that says that you owe, say, creditor A $100,000, and creditor A brings that judgment and registers it in the state of Alaska, where you've created a trust, some argue that Alaska will likely have to disgorge, or likely will disgorge, those monies. But other very knowledgeable and authoritative sources on asset protection say that's not true. Now, the law is very unsettled here, so there's some degree of uncertainty. But I tend to agree that if properly done in the proper jurisdiction, executing other documents that I won't get into here to firm it up, I think that you do have a pretty high probability that your funds are going to be safe. But if you go into this area, you're not guaranteed. Asset protection offers few guarantees. You're not likely to go to any lawyer that's going to issue you a money back or better and a full indemnity on the asset protection trust working as it's designed. And that's not to say that the lawyers are not giving you something of value and that they're not being as helpful as they can be. They are. It's just that when lawyers do some things where there's some uncertainty, it's unsettled, it's on the cutting edge of legal practices and strategies, etc., then those lawyers have to say to their clients, look, there's some uncertainty here. It's possible that you're going to spend the money that you're spending with me, and it's possible that these asset protection provisions will not hold up. That doesn't mean it's a bad idea. That's like, going to a medical doctor or a surgeon, and there's this very new experimental procedure. This procedure may not work, and so he says to you in advance, this may not work, and it could even produce worse results. It's possible. You all have had these disclaimers before. I mean, doctors tell you all the terrible things that could happen. Usually, an astute patient will, having considered the options and recognizing that this appears to be something that can be hugely beneficial to them, they weigh the potential downside and they go forward. And they don't generally hold the doctor responsible for that. Or if they do, hopefully this doctor has asset protection planning. But the point is, lawyers are in a similar situation in some areas of the law, and this is one of those. Now, you wouldn't undertake this risk unless you thought the potential gain, if this surgical procedure works, the potential gain is not huge. And that's my point. The potential gain is huge if, in fact, it works as designed. So let's talk a little bit more about those limitations that I covered earlier. When I'm covering the tools that you want to think about, we've mentioned contracts, we've mentioned trusts. But before I move on to other items, I want to integrate the fraudulent conveyance rules. When you're thinking about asset protection and you recognize that there are these limitations regarding fraudulent conveyances, I don't want to communicate to you or for you to get the impression that emasculates your plan or your purpose. It doesn't. It just says to those of you who already have creditors barking at the door, this asset protection trust will not be helpful, and particularly these domestic asset protection trusts in that area. And I would argue any of them, period, including internationally. It has the lawyer participating in a fraud that could jeopardize their license. So lawyers are not going to have anything to do with helping you out with these trusts if you have existing